Welcome to the deep dive. Today, we are strapping in for a really deep, quite challenging look at the evolution of justice itself.
Yeah, it's a huge topic.
Our mission is to try and distill this foundational shift in, well, the entire Western legal tradition. We've gathered a pretty substantial stack of sources here,
Right.
covering ancient legal history, everything from the blood feuds that defined early Athenian society, right up to the hyper-codified, almost bafflingly complex systems of late imperial Rome.
And it's not just history, is it? It's really the origin story of how we even think about right and wrong, public versus private.
Exactly.
We're examining this really seismic shift in what law even is. When we start in the ancient world, justice is so often governed by kinship, by these cycles of personal vengeance.
Blood feuds.
Absolutely, and often by quite archaic and flexible religious rules. But over centuries, we see this radical transformation. It moves towards rationalized, abstract systems.
Codified civil law, private law.
Exactly. Rigorous legal reasoning. Conceptual categories like contract and status emerging. It's a massive intellectual leap.
Right. And for you, the listener, this is about grasping some really fundamental conceptual challenges. How did ancient thinkers even justify their authority to punish? How did they structure something so basic as the family in legal terms?
Which is incredibly different from how we see it.
Totally. And maybe most critically, how did the administration of justice manage to move out of the, let's say, the private realm, out of the hands of the victim's family and their, need for satisfaction?
That raw need for revenge.
Yes. How did it consolidate into the public authority of the state? We're basically tracing the intellectual path that gave rise to the legal systems that define our world today.
Okay, so let's unpack this monumental shift. A good place to start, I think, is where so much of Greek legal philosophy and political thought really crystallized. That transition from the oikos,
The household, the family unit. Yeah.
to the polis, the public city-state. And the sources, well, they repeatedly point to Aeschylus's Oresteia as maybe the narrative that captures this moment.
Oh, absolutely. The Oresteia is often treated by scholars almost like a theatrical constitutional moment. It documents Athens choosing law over feud, right?
Yeah.
The whole trilogy is just steeped in the horror of familial revenge going back generations. Agamemnon's murder is vengeance. Orestes killing his mother, Clytemnestra, is vengeance for that.
It just keeps going.
It's this recursive violence that really threatens to tear society apart.
And the crucial pivot, the thing that makes it so significant for law, is how this cycle is finally broken. After Orestes commits matricide, he's hunted by the Furies.
Who are basically the embodiment of ancient blood pollution, of that familial need for vengeance.
Right. But the key narrative turn is that the final judgment, the one that will either sanction this endless cycle or break it, it doesn't happen in some old shrine.
No, it happens right in the center of Athens, in the law court.
Yeah.
Adjudicated by the goddess Athena and, crucially, a jury of citizens. That ending, that shift to the court, that's the key conceptual breakthrough for the polis, isn't it?
It really is. In the older world, like in Homer, the answers to conflict were all rooted in the inherited sacred order of the oikos, the household.
Right.
But for Aeschylus, writing later, the answer had to be public. It had to be reasoned. It had to be found at the polis. And Orestes, his situation perfectly exposes what some scholars call the tragic double bind of revenge.
Explain that a bit.
Well, the logic of the blood feud basically says, if you punish a wrong, you inevitably end up doing a wrong yourself, which just continues the cycle. But if you don't punish the original wrong, that's also seen as wrong, a failure of duty to the dead to family honor.
So you're damned if you do, damned if you don't.
Exactly. That's the double bind. The new political community, the polis, it had to create a system rationalized procedural law specifically to stop this self-perpetuating violence.
But what's so fascinating, and this really jumps out from the sources, is that even as the polis offered this rational solution, the actual process of justice didn't immediately get, sanitized.
Not at all.
Athenian courts were still seen as a perfectly legitimate place to pursue personal hostilities, this deep-seated concept they called ekthra.
And this is where it gets really interesting and just so different from modern ideas of law. Ekthra wasn't just, some bias the jury was supposed to ignore.
Like something to be rooted out.
Quite the opposite. It was seen as a valid motive for bringing a prosecution. Litigants would openly admit it, use it as a rhetorical strategy.
Wait, they'd stand up in court and say, I'm prosecuting this guy because he's my enemy.
Pretty much. Our sources show speakers literally declaring an opponent, an ekthros, an enemy, precisely to justify why they brought the case. And they'd ask the jury to convict him on that basis.
That feels completely alien. Isn't the whole point of, like, modern law to eliminate personal hostility, to have impartial state enforcement?
Well, yes, now.
Yeah.
But you have to remember the Athenian context. The state was relatively weak in terms of enforcement. They didn't have a professional police force or public prosecutors in our sense. So if the state couldn't reliably pursue justice on its own, it had to rely on the passion of the injured party or their friends and family. The litigant was essentially arguing, look, I'm prosecuting this man because he's my enemy, and he's my enemy because he committed a wrong against me or maybe against the state itself. So by punishing my enemy, you, the jury, are actually achieving justice for the whole community.
Wow.
Think about that passage in Lacius 15. The speaker flat out says he's seeking vengeance against a personal foe and asks the jury for a just vote. The two ideas, personal enmity and public justice, they weren't seen as contradictory. They were kind of fused by necessity.
So litigation becomes this sort of sanctioned, civilized feud, fought with words in the courtroom instead of spears in the field.
That's a good way to put it. In this highly competitive, agonistic society, the system relied heavily on private initiative. Litigants had to frame the facts, manipulate the context of that enmity.
But to convince the jury.
Exactly. To convince those hundreds of jurors whether this specific case was legitimate revenge for a real wrong, or if it was just another move in the constant petty tit-for-tat feuding that went on in Athens, the jury effectively became the arbiter of what constituted acceptable vengeance.
This reliance on private action really highlights why they sometimes needed more direct state mechanisms, doesn't it? When private action failed or maybe wasn't possible.
Precisely. Beyond the formal homicide prosecutions, the Dicai Phonu, which had strict rules about who could prosecute, usually the victim's kin, under Draco's old law, the Athenians had this other, rather chilling mechanism. Apagoge?
Right. Apagoge, summary arrest. Let's unpack that. It sounds like just, well, arresting someone quickly.
It was much more than that. It was a method citizens could use to prosecute suspected criminals, maybe habitual ones, or killers, especially if the strict kinship requirement for a formal homicide trial couldn't be met. But calling it just an arrest really undersells its primary function. Social degradation. Public humiliation. The procedure itself was the punishment, almost regardless of the outcome.
How did it work?
The prosecutor would physically seize the accused person in the street, maybe in the agora, right in front of everyone, neighbors, business associates, everyone.
Oh, wow.
And then force this incredibly humiliating public parade, dragging them through the agora to the office of the 11, the officials who handled criminals. The point wasn't just temporary lockup. It was immediate and likely permanent character assassination.
That's brutal. Why was the humiliation itself considered so effective, so important?
Because it struck directly at the accused standing, their honor, their time, within this small, intensely status-conscious community. Being dragged publicly through the agora like a common criminal, your reputation was instantly ruined, your status shattered, even if you were later acquitted.
So the process was the punishment.
In a very real sense. The Athenians explicitly saw this public suffering as a form of pathine, something you experience, you suffer in person. They deliberately contrasted it with just paying a fine, which was a podicai.
A monetary penalty doesn't carry the same shame.
Exactly. The body, the person's social standing, not just their wallet, were the immediate target of this form of state-sanctioned action. And, this idea of public humiliation as a tool of the state doesn't just vanish. We see stigma remaining a core element of legal and social punishment right through the Roman period. It's a long-lasting theme.
Okay, moving from that intense, very localized, very personal world of Athenian justice to, well, the vast abstract world of Roman law, that's a huge conceptual jump. We need some frameworks to understand how the Romans thought about this development.
Absolutely. And this is where we really have to talk about Sir Henry Sumner Maine. His grand thesis provides a framework that, well, generations of jurists and anthropologists have used to analyze this massive legal transition.
The famous phrase, from status to contract.
That's the one. Maine saw the movement of what he called progressive societies defined by this shift.
Let's unpack that framework a bit because it's so crucial for understanding Roman legal innovation. Maine identifies, what, 3 key transitions?
Broadly, yes. First, the shift away from the family unit where the paterfamilias, the head of household, held almost all legal power towards the legal recognition of the individual.
Okay, family to individual.
Second, the move from rights and duties being determined primarily by your inherent, often inherited, status, your fixed place in society, towards obligations arising from freely negotiated contract.
Status to contract, that's the big one.
And third, a shift from what he saw as early penal legislation focused on simple wrongs against the community or gods towards highly complex, detailed civil law systems designed to govern private relationships and transactions.
Maine's idea is a really powerful lens, isn't it? He argued that more primitive legal systems often struggled to clearly separate a wrong done to a person, what we might call a tort or private injury, from a wrong done to the state, a crime.
Right, the lines were blurred. But Roman law, especially as it developed, showed this remarkable capacity to move beyond that. It put immense effort into codifying and regulating private disputes. And the engine driving this, according to many sources, was really practical. Commerce and the need for speed.
That's fascinating, the sheer commercial pragmatism of the Roman jurists, this drive to remove what the sources call technical encumbrance from common everyday transactions, buying, selling, renting.
Letting and hiring, yeah. They did this quite explicitly to make things easier, faster, to facilitate the huge volume of trade happening across the empire. And this led to a distinct, incredibly useful class of contracts.
But consensual contract.
Precisely. The Romans recognized certain agreements, sale, hire, partnership, mandate, it's consensual, meaning they were legally binding based on mere mutual assent. Just the agreement itself was enough.
No need for special words or witnesses or writing it down?
Nope, nope. No formal verbal rituals, no required witnesses, no written record needed for validity. And they specifically identified these as contracts, juris gentium belonging to the law of nations.
Why law of nations?
Because these types of agreements were so practical, so simple, they tended to be recognized and used everywhere Roman influence reached, by citizens and non-citizens alike. They were, in a way, the backbone of the imperial economy.
But this simplicity wasn't universal across all contracts, which really highlights the layered complexity of the Roman system. Take lending money, a mutuum. The rules there could be much stricter, right? Especially regarding interest.
That's a crucial distinction, yeah. If you wanted to legally charge interest, usure, on a simple loan of money, usum, the standard civil law generally didn't allow it just based on the loan agreement itself. You almost always needed something extra.
Which was?
A separate, highly formal verbal contract known as a stipulatio.
Ah, the stipulatio, that formal question and answer ritual.
Exactly. Do you promise to pay me 10,000 sesterces plus interest next year? Splendeo, I promise. You needed that specific verbal exchange to make the interest legally enforceable in many cases.
Why the extra formality for interest?
Well, the Romans had a deep-seated suspicion of money lending for profit.
Yeah.
At least in its raw form. The simple loan, utuum, was conceptually closer to a friendly favor. So the practical business of lending for interest often relied on these quite archaic, formalistic, ritual requirements.
Requirements that those newer, faster consensual contracts managed to bypass entirely for things like sales.
Right. And this contrast is fantastic because it shows Roman law doing two things at once, holding on to ancient rituals for certain things while simultaneously pioneering incredibly flexible, pragmatic rules for facilitating large-scale commerce.
It's that tension again. If we connect this back to the bigger picture, we see Roman jurists grappling with really abstract conceptual challenges, especially when they try to define foundational ideas like natural law, esacius naturae.
Oh, natural law was a tricky one for the Romans. Conceptually, philosophically, it often seemed to confuse the past and the present. It seemed to imply this, well, perhaps mythical state of nature, a time when humanity was supposedly regulated only by universal, moral, natural principles.
Like a golden age.
Exactly. Our sources sometimes talk about it almost dismissively, as little more than a fancy of a golden age, something poets like Ovid wrote about, but not necessarily real history.
So, if it was rooted in this sort of poetic myth, was it irrelevant to their actual legal system?
Not at all, and this is key for understanding Roman legal thought. For the practical Roman jurists, natural law wasn't just some forgotten historical utopia. It was something they saw as relevant now, something intertwined with existing institutions.
How so?
Well, they used it as a kind of benchmark, something distinct from the specific civil law of Rome, aegis civil, even if their use of it lacked, say, the rigorous philosophical precision a Greek philosopher might demand.
Can you give an example?
Sure. Slavery is the classic one.
Yeah.
They might say slavery is permitted under the aegis gentium, the law observed by all nations, the practical reality, but argue it's actually contrary to aegis naturalis, which dictates that all humans are born free.
So it creates a tension.
A very productive tension. It allowed them to acknowledge a universal moral principle, freedom, while simultaneously justifying and regulating an existing widespread institution, slavery, under a different legal category, Christius Gentium. This ability to hold conflicting ideas in suspension, distinguishing theory from practice, was central to Roman legal scholarship and helped them manage the diversity of the empire.
Now, that Roman legal framework, as we've hinted, was anything but neutral. It rigidly structured society, particularly around gender and, crucially, status. Let's dive into one of the most persistent and, maybe to modernize, quite puzzling institutions. The guardianship of adult women, tutela mulierum.
Right, tutela mulierum. The guardianship of women, even women who were technically of full age and legally independent, sui juris, were often still required to have a guardian, a tutor for certain significant legal acts.
And the traditional justification for this?
The reason usually given by the early jurists was animi levitas,
Yeah.
literally sort of lightness of mind or frivolousness.
Seriously?
Yes. The underlying societal belief, deeply ingrained, was that women were generally more easily deceived or swayed, less capable of sound judgment in serious matters, especially financial ones. Therefore, they needed the constant authority of a tutor to, well, protect them.
Protect them or protect the family property?
Well, that's the question, isn't it? Officially, it was about protecting the woman, but it also very clearly served to protect the family's patrimony, the inherited wealth.
But the sources show that even within the Roman legal tradition, this justification started to wear thin. Jurists themselves became skeptical.
Absolutely.
Yeah.
You see this very clearly with the jurist Gaius writing in the classical period. He explicitly questions the rationale. He basically says that the common reason given animi levitas, especially for women of full age who were obviously capable of managing their own affairs, well, he found it specious rather than true. Plausible on the surface, but not really convincing.
So what did Gaius think the real reason was?
He suggests it was more about maintaining the traditional authority structure of the agnatic family, the family line, traced through males. It was a way to ensure that even an independent woman couldn't just unilaterally dispose of significant family property that might otherwise eventually pass to her male relatives on her father's side.
So it's structural conservatism winning out. Even when the intellectual justification is seen as weak, the rule persists because it props up the traditional family structure.
Precisely. It shows how deeply Roman law was geared towards preserving the family line and its property, sometimes even at the expense of recognizing individual legal capacity that was obviously present.
This principle, this legal rigidity based on status, is even more starkly obvious when we turn to the absolute cornerstone of Roman social structure, slavery.
Yeah, there's no avoiding it. Both classical Athenian law, as we touched on, and Roman law were fundamentally based on chattel slavery. The legal reality was brutal and clear. Slaves were property, things.
Commodities.
Commodities, exactly. Bought, sold, mortgaged, inherited, just like land or livestock.
And yet, the human reality underneath kept complicating that stark legal definition, didn't it? Creating that kind of legal schizophrenia you mentioned earlier, the one Aristotle picked up on.
It absolutely did.
Yeah.
You see these contradictions pop up in the law of remedies, for instance. The Digest, that huge compilation of Roman law, notes that if a master maliciously kills his own slave, well, he might be liable.
Liable to whom? For murder?
No, not for murder. He might be liable through a specific action, actio in factum, but only to a third party who had a property interest in that slave, say someone who held the slave as security for a debt, a pledge, or someone who possessed the slave in good faith believing they owned them.
So the liability is purely about the damage to the asset value for the third party.
Exactly. It's not about the sanctity of the slave's life as a person. The master generally faced no criminal penalty for killing his own property, however cruelly.
That philosophical paradox Aristotle tried to capture, distinguishing friendship with the slave qua man versus qua slave.
Right. He recognized you could have a human connection, acknowledging shared humanity, qua man, which he thought was possible.
Yeah.
But friendship qua slave, seeing them purely as an instrument, a possession that was conceptually impossible within the legal framework. The system acknowledged their humanity on one level, while utterly denying their legal personhood on another.
And this denial reached right into the heart of family life, didn't it? Making emotional bonds legally invisible.
Completely invisible. Roman law flatly refused to recognize marriage, matrimonium, between slaves, or even between a slave and a free person. Such unions had zero legal standing.
But surely such relationships existed. Long-term committed unions.
Oh, absolutely. We know they existed.
Yeah.
Stable, long-lasting, often monogamous unions between enslaved people were common. They even had a name for them. Contubernium.
Contubernium.
Yes. But it was purely a factual description. It signified a cohabiting relationship, often deeply committed, but it carried absolutely no legal weight. No rights of inheritance, no legal status for children derived from it, no protection against forced separation. It was a social reality entirely outside the legal system.
Looking at this whole picture, the persistence of tutela, the brutality of slavery's legal logic, you can see why, especially as the empire evolved, there was this growing need for some kind of, well, moral or even theological justification for these stark status differences. Why are some people free and others enslaved?
Exactly. Early religious thought, and later Christian theology particularly, stepped into that gap. It provided a moral framework that the law could then enforce.
Augustine, for instance.
Augustine is hugely influential here, writing during that period of massive transformation in the late empire. He famously argued that the prime cause of slavery is sin, that humans were put under other humans in bondage by a judgment of God.
So sin becomes the explanation.
It provides this powerful, overarching moral why for the existence of status distinctions like slavery. It frames it not just as a social or economic reality, but as part of a divine order, a consequence of human fallenness. This allowed the legal system to continue meticulously regulating and enforcing the practice of slavery, because the underlying reason for its existence was now located in theology, in divine judgment. The status was just the earthly legal expression of that judgment.
Okay, so the empire grows immense, incredibly diverse. The legal administration has to adapt. And this brings us to a really fundamental difference in how justice actually worked, depending on whether you were in the city of Rome itself or out in the vast provinces. We need to clearly distinguish the jurisdiction of the praetor in Rome from that of the provincial governor.
Yes, this is a critical distinction for understanding the lived experience of Roman law. In the city of Rome, the praetors held the key role in the initial stages of a legal dispute, certainly under the older formulary system. They exercised ius justitiae.
Ius justitiae literally saying the law.
Kinda, yeah. More like laying down the law, defining the legal issue, establishing the procedural formula by which the case would eventually be decided by a lay judge, iudex. It was a highly formalized process. The citizen in Rome knew or could find out the established rules and procedures beforehand.
Okay, structured, formal, predictable to some extent. Contrast that with the provinces.
Out in the provinces, it was a different world. The governor, who usually held both military and civil authority imperium, was essentially the fount of all procedural law in his territory. He didn't just set up the case. He was entitled simply to cognoscere.
Cognoscere. To know, to investigate, to try the case.
Exactly. To try the case completely, from beginning to end, right before himself. He operated under a system that became increasingly dominant everywhere, called cognitio extra ordinem, basically. Adjudication outside the standard order of the old formulary system.
So the governor just handles everything.
Pretty much. He could summon the parties, figure out what the dispute was about, hear the evidence directly, pronounce the judgment, and then order its execution, all based on his own authority and chosen procedure.
Wow, that's a massive concentration of judicial power in one person.
It's terrifying, really.
Yeah.
And crucially, this wasn't just for non-citizens or provincials. This cognitio procedure applied to Roman citizens living or traveling in the province just as much. Your legal experience as a citizen could be radically different, much more immediate, potentially far more arbitrary, depending on whether you were in Rome or, say, Syria.
And even though the procedures might become less formalistic, especially in the provinces with cognitio, that older Roman focus on public performance, on maintaining social hierarchy through things like humiliation, that didn't just disappear, did it?
Not at all. That idea of stigma, of public status being central, remained a core element right through the Roman period, including in the penalties handed out under the cognitio system. We see this really vividly in the detailed laws about inuria.
Inuria that covers insult as well as physical injury, right?
Yes, it's a broad category. And the severity of the penalty for inuria often depended less on the act itself and more on the context, the status involved.
Okay, let's unpack that definition of an atrocious injury, an inuria atrox. What made an insult or injury atrocious?
It could be several things, often related to publicity or status.
Yeah.
The place it happened, yelling an insult during the public games in front of thousands, was far worse than a private spat.
Okay.
The timing mattered. The person insulted was critical. Insulting a high magistrate or your parent or your patron, someone you owe deference to, that automatically made the inuria atrocious because it was a direct challenge to the social order.
And physical harm.
Naturally, the severity of a physical wound or the part of the body affected, like deliberately blinding someone, that also made it atrocious. The law was meticulously grading social transgression based on its public impact and the status of those involved.
And this system obviously had to deal with situations where the perpetrator was of lower status, like a slave injuring a free person. That must have been seen as particularly serious.
Deeply serious. An injury inflicted by a slave on a free person was considered inherently more insulting, precisely because the slave lacked full legal personhood. It amplified the affront.
So what happened then? What was the legal remedy?
The injured free person could bring a noxal action against the slave's master. Notice the action is against the master, not the slave directly,
Why the master?
because the slave was the master's property and the damage or injury originated from that property. The master was held legally responsible for the harm caused by his asset, but he had choices about how to resolve this liability.
What were his options?
Okay, several possibilities. One, the master could bring the offending slave to court and literally have him whipped in front of the insulted party, a kind of ritualistic public punishment to appease their honor.
Wow.
Two, he could choose noxal surrender, hand the slave over entirely to the injured party, essentially compensating the victim with the thing that caused the damage.
Giving them the slave.
Yes. Or three, the master could simply pay monetary damages, the amount usually fixed by the court based on the severity and context of the injuria.
And if the insulted party accepted the whipping?
Then their right to sue the master further was extinguished. The sources have this rather elegant phrase for it. It's as if the insulted party had swallowed their insult voluntarily. The public act of punishment satisfied the demand for honor, balancing property rights with social appeasement.
It's incredibly complex. Now, to really grasp the sheer sophistication of the Roman jurists, especially during the imperial period, we have to look beyond these broader issues of governance and status and get into the micro details, the kind of stuff preserved in Justinian's digest.
Oh, definitely.
That level of detail shows a legal system built for a society with incredibly complex property arrangements, doesn't it?
Absolutely. Some of the examples from the jurists are just, well, thrilling in their intellectual precision because they're tackling real, messy, everyday problems that arise from ownership and use. Take usufruct, for example.
The right to use and enjoy the profits of property that belongs to someone else.
Exactly. Now, imagine a will leaves a usufruct, say, the right to farm a piece of land for a year as a legacy to two men, but for alternate years. And, just to make it interesting, they happen to have the exact same name. Let's call them the two TT.
Okay, that sounds like a recipe for chaos.
Precisely. The jurists consider this. They point out with meticulous logic that unless these two TT come to some agreement about who gets year one and who gets year two, they're just going to constantly obstruct each other. The law has to provide a way to either force an agreement or impose a practical solution.
It's not about grand philosophy at that point. It's about making shared ownership actually work.
Down to the smallest, most potentially awkward detail. Or think about the complexity of property servitudes.
Rights that burden one piece of land for the benefit of another, like a right-of-way, insular, or a classic one, a servitude preventing someone from building higher, altius non telendi, to protect a neighbor's light.
Right. And the rules around these show Roman juristic reasoning at its absolute peak. Because rights are relative and situations get complicated. Your building might have a servitude benefiting neighbor A, but not neighbor B across the street. And what about accidental interference?
Give an example.
Okay, imagine property owner X has a right of light over property owner Y's land. But between them is property owner Z, whose land is not subject to any servitude benefiting X. Now, Z decides to build a taller building.
Okay.
Z's new building might accidentally block the light that X was previously getting over Y's land. What happens now? Can X sue Z?
Tricky. Z wasn't violating any direct servitude owed to X.
Exactly. The jurists concluded that X's claim against Z, arguing Z has no right to keep the building like that without X's consent, would likely fail. Why? Because Z does have the right to build on his own land.
But what if Z later tears the building down?
That's the brilliant twist. If Z later removes the obstruction, then X's original right of light over Y's property revives. The law recognizes the factual obstruction caused by Z, but it prioritizes Z's fundamental right to build on his own unburdened land while still preserving X's underlying right against Y should the obstruction disappear. It's an incredibly nuanced conditional outcome designed to balance multiple competing property rights.
This immense legal intricacy, this ability to handle such complexity, it's impressive. But finally, we have to connect all this back to the fate of the empire itself. Because if we look at the bigger picture, even this sophisticated legal machine couldn't ultimately prevent the system from, well, fraying or even collapsing in the late empire,
Yeah.
especially as imperial power itself started to become privatized.
That decline is, yeah, it's tragic to trace. In the late empire, the sheer cohesive strength of the central imperial government became increasingly diffuse, unstable, unpredictable. Part of the reason was this creeping privatization of power.
How did that work?
Well, holding imperial office, being part of the administration, had always entitled officials to give orders, make demands, enforce the law. That was legitimate state power. But when these officials started using that authority not for the state's purposes, but for their own personal gain, taking bribes, extorting money from local communities or elites in return for favors, or simply not enforcing burdensome laws.
Then the power isn't really the emperor's anymore.
Exactly. A significant chunk of the state's theoretical centralized power was effectively siphoned off. It became localized, personalized power, often wielded arbitrarily by corrupt officials or powerful local figures who had bought influence. It turned into a kind of localized tyranny under the guise of imperial administration.
So even if the total amount of obedience in the empire stayed the same, people were still obeying someone powerful locally, the emperor couldn't actually wield that power effectively.
Precisely. The strength of the empire couldn't be reliably brought to a single focus point by the central monarchy anymore. That centralized control was lost, as one source puts it, over villages and over towns and over cities and over their whole realm. This systemic decay, this rise of arbitrary personalized rule, really marks the end of the purely classical legal tradition and sets the stage for the very different world of late antiquity. #outro.
Wow. What an incredible journey conceptually we've taken today. We started way back in classical Athens, where personal vengeance, echthra, was literally a recognized legal strategy in court.
Right, part of the system.
Then we traced that massive shift using Maine's framework from status to contract and navigated through the dense thicket of the imperial Roman legal system, a system that governed everything from the immense concentrated cognitio power of a provincial governor.
Down to the alternating years of a shared usufruct between two guys named Titius.
Exactly. It's an amazing arc.
It really is. And I think what this centuries-long evolution shows, from blood ties and vengeance to hyper-codified contract law, is this continuous, persistent search for order, for control.
Control over what?
Well, initially, maybe control over the raw, destructive passion for familial revenge in the early Paulus. But later, control over the incredibly complex allocation of property rights, duties, and statuses across a vast, diverse Roman Empire. At the end of the day, the law was always the primary mechanism trying to define and enforce the structure of social reality.
Okay, so here's a final provocative thought for you, the listener, to chew on. We talked about the late empire universal citizenship blurring all lines. Justinian faced this monumental challenge. How do you integrate this vast, diverse world under a single, unified body of law?
A massive undertaking.
Some sources suggest one way he approached this, conceptually at least, was by effectively redescribing all of the soil in the newly reconquered or redefined empire as fundamentally Roman soil, thereby subjecting everyone on it to the highest, most developed form of Roman law. Now, if the legal system of late antiquity, the system we've seen wrestling with the two TT, was that powerful, that intellectually sophisticated.
Capable of imposing these complex principles.
Right. Capable of imposing them on this newly unified citizenry across the Mediterranean world. Does that suggest that maybe law, more than military might, more than administration, more than anything else, truly defined the boundaries, the coherence, and perhaps the enduring identity of that late Roman world?
That's a fantastic question. Was law the ultimate container?
Definitely something to mull over.